Commissioner Adira.
Here.
Commissioner Kasher. Commissioner Wasserman.
Here.
Commissioner Wynn.
Here.
Chair Remke.
Here. Good morning, everyone. I just want to take a moment to highlight some of the work that's being done on our website right now. Two main things. Take a moment to go ahead and click on the heat map at some point. It's been updated to include all the enforcement actions for 2015. Thanks, Sheila. So that's looking really good, and we're going to continue to keep it as current as possible as we go forward. Also, some of you may have noticed what I like to refer to as Jay's fireside chats. Our communications director, Jay, is putting up monthly, if not more, videos on kind of just the highlights of what's going on and what's coming up. So again, we're just trying to use the website as much as possible to get information out there and as easy a format as possible. So thanks to all the staff for their work on that. Before we begin with items on the agenda, is there any public comment for an item not on the agenda today? Okay, seeing none, we'll go ahead and jump right to the consent calendar. And I understand that we are polling. Oh, they were so small. Yeah, I'm sorry. I go ahead, Galena, have a seat. But I did jump over the approval of the commission meeting minutes from April 2016. Do the commissioners have any corrections or questions regarding the minutes? Is there a motion?
I move approval of the April 2016 commission hearing minutes.
Second. Commissioner Adira.
Yes.
Commissioner Wasserman.
Yes.
Commissioner Wynn.
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, great. Thank you. And now we'll go to the consent calendar with Ms. West.
Yes, I propose moving item number 3, as there's been a development that I'd like to report back on for action.
Okay, so we're going to pull item 3 from consent, but we'll be discussing it. Are there any other items that the commissioners would like to pull from consent?
I'd like to pull item 4.
Okay, item 4. Any others that need to be pulled so they're not part of the consent, not for questioning, but just as issue of whether or not to stay in the consent?
Item 5.
3, 4, and 5. Anything else? Okay, so as for the remaining items on consent, items 6 through 30, do the commissioners have any questions for Ms. West?
I do.
Okay, please, Commissioner Wasserman.
Okay, I have some questions and some comments. I'm just going to go down. Number 4, most of that.
So that's been pulled from consent.
I'm sorry, I thought you were saying.
We pulled the first.
Thank you. Then mark it down by 4 and 5. I didn't double check the stipulation on 10, but the actual name of the matter should be conservation voters. It's the kind of thing you can't pick up in spell check. It is an actual word. So
Well, that would be a very interesting organization.
with irony, I state I join. Okay. And thank you for that. I'm here all morning. Let's see. 15, which was a SCI non-filer. As I understand it, this is someone whose statement, the reason they didn't file was because although their status was as a consultant, they didn't realize they weren't doing any actual work. They still needed to file.
Right.
Okay. So that's just a question of education on that end. But the expectation with this person really should have known, and that's why that misunderstanding is a $1,000 fine.
Correct. And Galena West Enforcement Chief. And also once someone from an agency actually tells you that you have to file repeatedly, and then other people do as well, then we assume the knowledge, yes.
There's a duty for you to really double check once you've been informed. And if someone who you should be listening to tells you, you should be listening.
Correct.
And you should act. On 17 SEI, these are, what, do we have information as to when these were eventually filed? This was a assuming office SEI in a 2014. I think this was streamlined.
You can assume generally that they were filed after contact by enforcement because most things don't even come to us as a referral unless they haven't filed at all. So after the contact's by their filing officer, they still haven't filed. Then enforcement contact, they still haven't filed. This is a 2014 case, so the filings didn't happen for quite a while.
Okay.
But all filings happen with the settlement. Or you can't come here.
Right.
You don't get to play the game.
19, which is also, it's one of our SEIs and leaving office statement. I was trying to make a note of what the difference between this case and case 15-2199 was, where an individual got a warning letter for a 2000 failure to file 2014 SCI and the leaving office, then left office in 2015. And I think there was some difference, again, some additional fact that it's escaping me at the moment that rendered this beyond warning letter to actually, well, this is kind of like an infraction level fine, I suppose.
Right. What was that 15 dash what?
2199.
Not that I have every warning letter memorized, but I do have the criteria memorized, which means that this one had an annual, which is a separate violation for a different annual. This combined, the second count here combined the annual with the leaving office statement, which we do if the leaving office statement was due within a certain amount of time to when the annual was due. So you can still get a warning letter if the overlap of what your leaving office statement was so great with what your only single annual that you missed. And then that way we're not tracking down everybody that's out of office in addition to the 100,000 filers of SEIs. And so in this case, the one on the agenda as 19, there was a second annual that also wasn't filed. So once you don't file for a whole year plus a year, then you're not going to get a warning letter.
Okay. I have a much more general question. I'm going to defer to the enforcement report period. So, and then we have a number of these cases coming out of the city of LA with respect to SEIs. With respect to the LA Ethics Commission and how they're set up, do they have anything else that goes on related to, in conjunction with or related to these violations that we deal with?
We work in coordination with all of the local commissions, and in fact, Oakland has reached out to enforce their own SEI violations, and we're always open to the locals doing their own SEI enforcement, but they have to have it within their own code, and so it's whether or not LA has the ability that they've granted themselves to do these violations. But we work with all the different local ethics agencies.
And that was why I was curious, because they're major metropolitan entity with our own freestanding commission, which is very active and does a lot of things. That's sort of, we're dealing with their SEI. Okay. And that is all.
Any other questions or comments from the commissioners regarding the remaining items on consent? Public comment regarding the remaining items on consent 6 through 30. Okay, seeing none, is there a motion?
I move approval of the consent calendar items 6 through 30.
I'll second that.
Commissioner Adara?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Runke?
Yes.
This motion passes.
Okay, then we'll take each item that's been pulled, starting with number 3. And there has been a development in this case, which is what Glean is going to talk about. And it is a stipulation has been reached on this matter that was presented as a default. And for anyone who is interested here, there are copies available, multiple copies available, so please take one. And then it's also been posted on the website for anyone who is actually listening to this and would like to see what's happened in the development with that. Ms. West.
And as the chair said, there has been a development in this case. Proper notice of this action has been provided under open meeting laws in Bagley-Keene because it requires notice of the subject matter and a brief description of the action item. So this still is an action item that you can act on. And the commission's policy, as always, is to encourage settlement and for respondents to admit to their violations and take responsibility. And Mr. Strickland has reached out to us in order to do that. So to facilitate him to be able to take responsibility for his actions, we're presenting you with an alternative to the default, which is a stipulated settlement that has the admissions included. So we've constantly worked with the parties throughout the process, and we do give deadlines during the process that people are able to meet. And Ms. Brereton is up here with me she's the attorney on the case, to speak of the deadlines that have passed and how we came to this point to have it as a default in front of you. And after being reached out to, we got a statement from the treasurer who had formally not participated and included her statement in the settlement in order to get her point of view included and represented. So we recommend that you adopt the settlement. It will also help us in the future because, as you can probably recall, this is a three-pronged case that has a Stanislaus committee, the Ventura committee, and in March you approved the agenda item for the Stanislaus committee. And then the Ventura committee last month you approved for us to go to an ALJ. So that is proceeding all the way to administrative hearing. Having admissions in this case, as well as in Stanislaus, will bolster our case in the Ventura case. So there are reasons why settlement is not only good for taking responsibility, but also for facilitating administrative action against all responsible parties. So we're here to answer any specific questions that you might have.
And obviously, can you explain to us what, if any, changes there are in the facts or the violations from the default proposal order and the stipulation that's been entered? So fact, violations, and ultimate fine proposal, just so we're all clear what we're discussing.
Angela Brereton, Senior Commission Counsel. As far as the facts go, the actual statement of the facts that's in the stipulation and in the default, there are no changes. The only change that has been made in the Exhibit 1, other than taking out all of the procedural history, is Ms. Ray's statement at the end of, I believe it's on page 14, the last paragraph. So that is the only addition that's been made. Nothing else has been taken out other than the procedural history, as I mentioned.
So that's on page 14, last paragraph, on May 17th.
Yeah.
She sent a written statement. So that paragraph regarding that, as Ms. West was saying, her position as to how her role in this.
Yes.
Okay. So those are the facts. Otherwise, all the facts are the same as they were in the proposed default. And then let's talk for a second about the violations.
Yes. So the violations are the same as far as the statutes that are included in each violation. The difference is that instead of having a separate violation per contribution per statute, the statutes have been combined for each contribution. So there's a single count for each transaction that occurred for the laundered campaign contributions. We've done this in other cases. In the Stanislaus case, we did it, we combined, there weren't multiple statutes to combine, but we put both of the transactions for Stanislaus into one count because they agreed to settle. And same with the Jim Nielsen matter, which was last summer. When the parties cooperate, we are much more amenable to focusing on the transactions that occurred rather than laying out each individual violation that we can possibly charge, which is what we do when we're charging the case in an accusation, which is why the default is presented that way. But for settlement purposes, having somebody take the responsibility, we are much more amenable to combining those and just focusing on each transaction.
So we went from 16 violations to 8 violations, is that right?
That's correct.
Okay, but each of the activity remains there.
Yes.
Right, okay. So false information in campaign statements,
Yes, we have.
over the limit, earmarking, each of that type of activity is still represented in the stipulation. So we still know the scope of the misconduct.
That's correct.
Okay. And then can you help us understand the change in the penalty?
So as you know, our maximum fine is $5,000 per count. So by combining the counts per transaction, we have fewer counts, but we still are requesting the maximum fine, even though this is a settlement. For other cases like this, such as the Nielsen matter last summer, we did not request the maximum fine for similar activity. But the facts there were different in that the amount of the transactions was much lower. Many of the transactions were actually not, many of the transactions that we were investigating that were part of the facts of that case were considered member communications, so they were not included in the amount that was a violation. So that case, there were only about a little over $4,000 worth of communications that were not acceptable. However, in this case, it's a significant amount of money. And so we need to have the max fine, even though it's a settlement per count, because it's very serious, the evidence that we have. At the same time, Mr. Strickland is willing to take responsibility for his actions, which is a big deal when our maximum fine is only $5,000 per count. We have some teeth there to be able to show, look, we need to have an admission if you're going to settle with us, because we need you to take responsibility and hopefully show that other people then, when they come in the future, we can say, look, this is how we do business. We require you to accept responsibility for your actions, no matter how bad it looks.
So that brings us from the 80,000 proposal in the default case to the 40,000 in the stipulation.
Yes.
So just to summarize, so we're all clear on that, if there's no confusion of the scope of change, it's adding the one paragraph in the facts regarding the treasurer. It's combining the violations from 16 to 8 and reducing the fine from 80 to 40. Right?
Yes, that's
Okay.
correct.
And I would just point out, and we have the $40,000, correct?
Yes, we do.
Okay, where, of course, we wouldn't have the $80,000, and we would step ourselves into a default process of collections. But okay, questions from the
I
commissioner?
do have one more thing to add. if you
Okay,
don't
sure.
mind. I would also like to point out that Mr. Strickland is no longer in office. He is not also actively running for office. So that is also a consideration we take into account when we're reaching a settlement with the party.
Okay. Commissioner Wynn?
Well, thank you very much. I was very supportive of the proposal that came to us last week with the default and the maximum fine to the 16 violations. But I really want to commend staff for continuing to work, because I do think we're better off with the stipulation, with an admission of responsibility. So I commend you for your hard work on this case.
Commissioners?
I also was very supportive of all the work that you did, and in fact, I had some notes to make sure to commend everyone, because I thought it was a really good work, and it was great that we got that everything that it took to bring us to a default of $80,000. I worry about the message of Strickland took responsibility, Strickland cooperated. I'm not sure he did. I mean, did he really, other than come to you, I don't know when, maybe last night? I don't know when, and I don't mean to be disrespectful, so just correct me where I'm factually incorrect, but it seems like he came to you possibly after the $80,000 and cooperated and did what? Gave us an admission that we now value at $40,000. So I'm just a little concerned about the message of we really mean business here, because I feel like he just bought his way out of all sorts of problems for 40 grand.
Can I ask a question? Was the proposed settlement along the way, because I know you guys have been trying to reach a settlement, was it always the proposal at $40,000?
Actually, it was less earlier on, but with early cooperation. And where they actually cooperate in the investigation as well as the negotiations. And this was, obviously it's always in response to a giant dollar amount, but what it truly is the default is no admission. And if the price of that admission is $40,000, having that responsibility taken, whether or not, I agree with you. I don't think cooperation is a word that I would use in this case. And as you can see from the default documents, you would have a lot more information about the procedural history of this case than you normally would in a stipulated settlement. You see the amount of time that we've taken working with them, and how his attorney may have been one of the stumbling blocks. And so when Mr. Strickland is the one that was reaching out and saying, I do want to take responsibility and I want to fix this, it's when we're responsive. So for us, it is a dip in the amount that we're charging. But since it's more in line with the other settlements that we do, we still are consistent in the way that we prosecute it, whether or not somebody stonewalls us for a while and comes at the 11th hour or not, we still get the admission and the responsibility and a large fine.
And I guess I would add the obvious, but it's also, I don't think it's fair to compare the 80,000 we would have got by a default versus the 40,000 here, since the 80,000, not that you were overcharging, but you charged to the full extent possible, like we were discussing every single step. I mean, I still see this stipulation as a very strong case with a very high fine in light of our other similar cases on these issues.
And the things you don't see are the number of cases very similar to this that people wait to the absolute last minute before they settle their case. And so I think maybe I'm a little more immune to that, but I do understand the message of, listen, you have to follow these deadlines because we still have to move these cases in a timely manner. And that's something that's the word is getting out, that these cases will be moved to default. And the commission has been very consistent on doing higher default fines because there's no admissions, and that has supported our position. So we're really making progress in that department.
Any other questions?
Yes.
Commissioner Wasserman?
All right, I've got one question and one comment. So the question goes to something you talked about, we've done before, and we constantly are dealing with in terms of, I'll call it prosecutorial discretion in terms of combining counts. Sometimes we have a couple of statements and we just make it one count for two statements. And in this case, we have the same act of receiving something, but violating both the acceptance of prohibited earmark over limit, and then without disclosing the true source. Two separate sort of statutes instead of the same statute twice. And you indicated we had done that before in, was it Nielsen? Yes. Nielsen. Okay. And you're satisfied that rather than saying each count individually, the facts of which are admitted to irregardless, that what we're attempting to, the value we're attempting to extract here is actually going to be in these documents. That by stipulating to this sort of combined thing, we're stipulating all the underlying facts that are necessary and serve the purpose of this stipulation, which is continuing the process of enforcing the laws in this case, the next case, and setting sort of standards for the future.
correct?
There we go.
Well, and if you look at what we chose to combine it into, look at the titles of those. It's receiving contributions over the limit that are earmarked, illegally earmarked, and the false reporting of those statements. That basically tells you the entire scheme by having those counts together. And the story is there, and it puts everyone on notice that these are the stories that we're going to expose.
Sure, yeah. Counts 1 through 4 combining prior counts 1 through 12, and counts 5 through 8 becoming counts 13 through 16 becoming counts 5 to 8. But those ones remaining essentially unchanged,
Correct.
as opposed to a different variation. So as
Because
long
the
as that
false
does the
reporting
job,
is the cover-up.
as long as it does the job, then that's fine.
Okay.
So the second, the comment was, and it's actually not particular to this particular respondent, but you made a statement about not being an active candidate. I think when we're dealing with candidates at this level, they aren't active candidates in the sense of that they are continually part of the process. They're repeat players. So, but that doesn't really change the overall landscape of this. I just wanted to.
Just makes the admission all that more valuable.
Thank you.
Any other comments from the commissioners? Okay, is there any public comment on item 3? All right, seeing none, is there a motion? Well, I will move to approve item 3. I'll second that.
Actually, I have just one other comment that I just.
Okay, go ahead, Commissioner Wasserman.
I understand when you've got a stipulation, it's hot in your hands, you're good to go, and the matter's been noticed. We're in compliance with that routine. The respondent obviously is fully aware of what's going on. People who are interested in this have an opportunity to know what's going on. The concern that I'm going to express is probably greatly lessened, but I'm always concerned about the opportunity for others in the public to chime in and say, hey, was this enough, et cetera, and express that. So luckily, I think the commissioners themselves have asked the questions that have been answered by staff as to that sort of thing. So I think that viewpoint is represented, but I just wanted to make that comment.
Any other comments? Okay, we have a pending motion.
Commissioner Adara,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, item 4. Any comments or questions from the commissioners? Commissioner Darrow?
Yes, thank you. I just, a little bit more background on, I think just the law, and indulge me if you will, but so when we compromise these matters, we are looking at the penalties that would be imposed through the administrative process. Is that correct? We don't look forward to what might happen if it goes outside of the it doesn't get resolved at the administrative process, through the administrative process, and instead gets resolved. Would go through a civil process, for example, right?
You're talking about fine comparison, or?
Yeah, I mean, I'm trying to understand. In this particular case, I think the maximum penalty for the 7 counts was $5,000 each, and so that's the number that was compromised. If this were outside of the administrative process, if this was in civil, what would be the penalties?
Well, each
What could happen
penalty
here?
violation can be up to the amount not reported,
Right.
and then also there's a limit on what each section, of course, because the act is very clear. Each section has a different limit in civil action.
Okay, so if this were in a civil action, then the dollar amount that we're talking about is about $79,000, correct?
It's true, but it's also an administrative action because the 3 treble damages for advertisements is under administrative actions. So we do take that into consideration for the administrative action. But I think the crux of your question is, when we're first evaluating the case, we're evaluating whether or not we should bring it to you as a civil action or administrative action. So we do go through a public harm analysis. A long time ago, the direction from the commission for civil action, which I haven't brought back to you, but I'm waiting for a good case to, is it's really about inadvertent, negligent, and intentional behavior is what the commission has found to be the most important factors when deciding between administrative and civil. So we're constantly looking for those factors. And as well, there are a couple civil statutes that are actually lower than the 5,000, if you can believe it. And so there are some times when the intentional is there, but the fine would actually be lower under a civil action. So we do consider that, and we are looking for that, especially for reporting violations where $5,000 would be inadequate for how much was reported incorrectly or not reported at all. So those are considerations we take at the beginning when we're trying to decide which avenue to take. But as to the possibility of this could be $1 million because $1 million wasn't disclosed, that's once that civil avenue is gone, then we're looking at the $5,000 for comparison. I don't know if that helps you.
No. Okay, perfect. That's exactly what I needed to understand, and I appreciate that. And I think this is not just as to this particular matter, but just in general. I see how much work is done by the commission on really getting the message out, and I feel, and this is not, again, not to this particular matter, but sometimes I feel like these compromises end up showing that these laws don't have much teeth in them. I mean, here, if you look at what could have happened, had this been brought as a civil, and I respect your decision absolutely to bring this as an administrative action versus a civil action. I understand that, and I get that that brings us into a whole different ballpark of
Evidence and proof.
Sure, of course. But at the end of the day, if somehow you can be convinced to bring it as an administrative action rather than a civil action, then it costs very little to violate these laws. I think that's just kind of the thing that I get, and I'm new to this, I haven't even been here a year, but it just kind of keeps coming at me that it's just like, really, I mean, this guy ultimately, if 79,000 is what was at issue, a $14,000 penalty is 20%. And sometimes almost someone could make the decision that, well, it's worth it. It's worth it to violate the laws if all it's going to cost me is this 20%. In this case, 20%. In other cases, different number, of course.
Cost.
Right.
And we do try to take that into consideration. Like, for instance, if you notice at the beginning of this exhibit in particular, this settles his 2011 and 2012, whereas 2013 and 2014 actions are part of a separate action. So this is a small part of a puzzle. And so when we're considering civil action has a shorter statute of limitations. That's 4 years for us instead of 5 for administrative. So when we look back, when we're digging into a case, because these cases don't necessarily come to us the year of the violation. So you get a 2016 complaint about a 2011 activity. So, but you're right, and the thing that is great about the commission and how the enforcement division reacts is when you give us direction and you say, no, we want to see higher fines for this type of violation, or we're interested in civil litigation for these types of violations. These are the directions that we internalize into our policies and procedures. And like I was making the point with defaults and the higher fines, it helps us in the negotiations that we're saying the commission is giving clear direction and the chair has said this, and this is the direction that we're going in these cases. So we're deviating from the prior comps in a higher way because of this. So this is all a good direction for us to help us consider the cases that are coming down the road.
I think this is a good time for me to jump in, just because there was a comment recently restating something I had said, and I think it was a real strong misstatement about our ability and willingness to go to trial. And I just want to stress for everyone, because the enforcement's doing a fabulous job. They're a strong team. They're fully staffed right now. They're ready for the upcoming election, and they have the resources to take a case to trial when necessary, and they will do it every time. Now, I was talking with someone, and it was again, I think a strong misstatement of what I said. And it goes to your point, Commissioner Odero, about civil versus administrative. And you use the word compromise. I would stress that it's not a compromise, it's a stipulation with an acknowledgement of wrongdoing and an agreement to pay a fine. But because and I only say that because this process, like all adjudicatory processes, 90% of more cases are resolved by, as you know, a stipulation, a settlement. That is the only way we can function in a timely, efficient manner. When last year we had a record number of cases opened, over 2,000 cases. That's double the number of cases opened the year before. I mean, and all this was done at a time when enforcement set 2 record years as to the number of cases they brought to us for fines. So the number of cases coming in the door are off the charts. They continue to process cases through the administrative process at record numbers. And I just want to commend them for doing this. But yes, the commission will take a case to trial if that's what's best for the case. So there's no holding back, and I know that's Galena's position, and I know her team's behind her on that. So to the extent that was a thought out there or premise, it's wrong.
Excuse me, sorry. I just wanted to add on the civil actions that Galena is going to talk a little bit later about some of the pre-election efforts that enforcement is undertaking, both before the June primary and then also again before the general. And one of those is to potentially pursue civil remedies in terms of injunctions to compel compliance before the election. And that's where, obviously, as you said, you just started on the commission, but in the past, that's where we've seen some more civil actions because of the timeline and because we want the injunctive relief to compel certain actions. So she's going to speak more about that, but I think that's relevant to this discussion as well. So my thunder.
No, you're still going to get your thunder, don't worry. It's worth repeating later.
Can I just say that
Commissioner Wasserman?
what the chair just was talking about compromise versus stipulation is a very important distinction. After we make these decisions, someone had asked me before, is this more like a plea bargain in a criminal matter or a civil settlement? And really, I should have said neither and both, right? Because it's more they are stipulating to the violation, to the facts. Unlike many civil settlements where folks say, we admit to no wrongdoing, but we'll pay each other to go away. Because in our cases, we are getting admissions, as was pointed out in the prior item, which are critical to what we do educationally in future enforcement, even with the same parties later on. Because I don't want to overstate by saying it's one, but understate by saying it's the other. But I think that was a good thing just to bring up again, because we see that time and again. What is the significance of this determination? Well, there is an admission on that. With respect, Commissioner Dara, I don't know if you can finish with your questions. On this particular item, the only thing I just wanted to note was that related to all the progress that this agency is putting effort into and around the state to get our technology up into place, because this is exactly the kind of case where perhaps, still would require someone to input it into the computer, right, step one, but most of these violations, if not all but one, if the technology were there and someone put in the information in a timely fashion, then we wouldn't have the need for these major donor reports again and again, because they just put in, or in fact, if it just comes off the contribution reports, the donor themselves wouldn't have to file anything. So we continue to strive for something better. But in the meantime, this is what we have. And they must comply.
Okay, any other comments from the commissioners? Any public comment on item number 4? Is there a motion?
I move approval of the stipulation.
Second.
Commissioner Adero,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Rumkey.
Yes.
This motion passes.
Okay, item number 5. Questions or comments from the commissioners?
question, and really just to highlight it for my fellow commissioners and then to just vote on it, is whether the total proposed penalty is sufficient for this conflict of interest case, where the council member represented his client before his city's planning commission. You might restate some of the things you said before about the value of resolution, etc. But if you don't mind.
Sure. One of the interesting things in this case that makes it different than other conflict cases is that he did disclose. So it was one of those conflict cases that's a little easier to find because he's making all the proper disclosures. He didn't think that since he is a city council member and he wasn't appearing before his own commission, that he would have a problem. And under the act, when you have the budgetary authority over another commission, you can't go and try to influence their decisions as well. And so the reason that we recommended the 3,000 was because he honestly believed, but through his disclosures and through his statements, that by representing at the planning commission as opposed to the city council and appearing during the public comment portion and then making comments instead of making a presentation, that he was within the rules. So there was a little mitigation in the misunderstanding of the rules. He's been educated now and he understands what he can and can't do to represent his business.
Yeah, I'm just not yet convinced that really is a sufficient mitigation. You're the councilman appearing before your own planning commission, and it doesn't fall into, it's not about your own house or something like that. It's in a paid position to represent a third party. I mean, it's all, I don't know, it feels kind of intuitive to me. I could be wrong. There could be a lot of different intuitions and compasses.
Well, you've been doing this a while now.
Well, that's also right? You have a little bit of experience or bias depending on where you sit. What was the outcome of this matter at the planning commission level? Do you know?
I think that they had to take it under advisement and then re-present it later on where he didn't participate because of the comments that happened during the meeting, is my recollection.
Because he couldn't, if it were something that, I don't know what the structure of that city is, but say the planning commission comes to a determination that is then appealed to the city council, which he sits on.
Yes, he obviously did not participate in the city council, and that would be included in your stipulation.
Or a future, yeah. Okay. Well, I mean, I think I've articulated my concerns, and I understand the statement of the mitigation. I'm just not there with it.
Commissioner Wynn?
Well, I appreciate Commissioner Wasserman's comments on this, and as is often the case when I'm reading through the material before the meeting, I always kind of think, I wonder why this fine is this way, or I wonder why this, they didn't throw the book at him or let her off too easy or whatever. But, I really just give deference to staff, which I know works hard to enforce the act, and they know the facts better than I do. And if it's kind of ballpark, I just defer to the staff on this. I read this one the same way and thought, wow, it's a conflict of interest case. We usually are a little bit harsher with that, but it does seem like a reasonable explanation in the context of a case where I didn't really deal with a lot of the facts. So, but I do appreciate your comment. I mean, I think it's something that we all grapple with, but I also appreciate so much enforcement's real thoroughness in kind of going over and really trying to be fair at the same time, enforcing the act. So,
and again, with stipulations, as we all know, a couple of things. Sometimes all the facts aren't in there because it's negotiated language, number one. Number two, we really don't know about the weight of the evidence. And that goes to Commissioner Wynn's point about giving deference to the prosecutors on understanding, they understand their case and what it would be like to have to try to prove this at a hearing. So I think all those factors go into it. They're often not in the stipulation.
And I would add two things that as a stipulated settlement, I can't speak ex parte beyond the document and what you see. And then also, we do give you the comps of what we see as the most similar things that you've approved in the past for the guidance. So because really the consistency is the main goal for us, we're trying to look for cases that have the most similar facts and apply them the same way. So those would be the only two additional points that I would make.
And certainly, I think we all agree about the amount of effort that's put in, the exercise of judgment that is necessary. But I think the point that's been really made is reasonable minds can disagree within a spectrum, and that's fine. I will vote the way I vote.
Okay, any other comments from the commissioners on item 6?
5.
Okay, any public comment on item number 5? Seeing none, is there a motion?
I move approval, 5.
Second.
Commissioner Adara,
Yes.
Commissioner Wasserman,
No,
Commissioner Wynn.
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, now the thunder begins. So Ms. West is going to tell us about enforcement efforts and how they're gearing up for the primary and general election coming up, and the special work they are working on. Again, I just want to take a moment to praise the enforcement division. And obviously, everybody in the commission is doing an excellent job right now. But in addition to, as I mentioned, the incredible increase in cases coming in and being opened with the same staff that we had the year before, and the year before, we also now have to gear up for election. So it's a very commendable job. Thank you, Ms. West.
I'm sure you guys are wishing for Hyla Wagner right now, but no, more me. So I just wanted to touch on what our compliance efforts that we make for the 2016 elections. And I was going to make a joke about what election, but I figured inappropriate. But so we're dedicated to seeking compliance before the election. As you know, that is the focus of the commission. And so we work with the education division, the SEI unit, and the legal division in order to gain compliance as much as possible. In fact, we have someone assigned to enforcement in order to help people get their disclosure correct before the elections. And so as we head into 2016, I just wanted to give you the 4 main points. So we ensure that the candidates on the ballot file their pre-election campaign statements. So that's something that we've been doing. The 2014 election season was the first time it was a full onslaught effort. But before that, it was more hit and miss. But we proactively ensure that candidates are filing their required reports. And in 2014, the staff reviewed the cities based on competitive elections in the jurisdiction and the population, and they focused on the second pre-election statement. And we've actually gone beyond that this year to where we're proactively contacting all the counties in California who do not have an ethics commission, and all the cities, large and small, that are having June elections. And so all the non-filers are identified. So if you're on the ballot and you've been identified, then we've contacted your clerk for compliance. The results are that 36 counties and 12 cities reported that all candidates and committees have filed. And then 14 counties and 2 cities had 1 or more non-filers that they referred to us. So we contacted 43 people, or non-filers were referred, and 38 have already filed as a response to our contact. So the last 5 are getting civil demand letters to where we say we're going to file an injunction against you to make you file the statement. And those last 5 are getting those letters overnighted to them, so they'll wake up to a special surprise. And so we work hard to make the compliance 100% before the election. Another thing that we do for November, we monitor the disclosures on the statewide ballot measure advertisements, but for June, we track down unidentified mailers and signs. So in 2014, we reviewed state ballot measure campaigns, and we'll continue to do that in the months that go up to the November election. But for June, we follow all leads, big and small. And we had a big meeting about it yesterday where everybody got to see if their case had a good lead or a not as good lead. And so we track down if signs are posted that don't have the identifiers, or flyers have come, mailers have come to your house. And we track down who the sender is. And we're working with ways to get the word out to the local jurisdiction about who the true sender is before the election. So we're working with the press office and the respondents themselves in order to get the word out, especially for people that just weren't aware of the rules and triggered $2,000 and became committees. So that's something that we're working to make sure that complete disclosure happens before the election. We're swiftly reviewing all the San Bernardino candidates as part of our contract. We continue to do that to achieve 100% compliance. And then we quickly review and respond to the complaints filed. And this is a critical component because, as you all know, complaints can be used in campaigns, both for good and evil. And so we never give anybody extra credit for turning somebody else in. We just take it as any other complaint. And so we review them as quickly as possible in order to dismiss the ones that don't have merit. And our intake division works very hard to give solid recommendations on whether or not something has some merit that we should open a case on, because we take it very seriously, the difference between a complaint received and a case opened. So it's a huge difference to the people that it matters to. And so we put a lot of due diligence in, and we make a lot of effort to make sure that we make the right decision. So those are some of the things that we're working on, and we'll continue to track down those last 5 non-filers and work on every lead to get the local jurisdictions the right amount of disclosure on their yard signs and pictures on Facebook of yard signs.
Okay, any questions from the commissioners?
Sure.
Commissioner Wynn?
Yeah, I just want to thank you so much, not just for the work you do, but for really letting us know how, complex, your outreach is. So I really appreciate that. Thank you very much.
I'll echo that. I think that the work that you guys do is amazing, and getting ahead of it. I'd much rather have you not collect as much money. I know it sounded different a few minutes ago. But obviously disclosure is what it's all about and what the game is here. So thank you and good work.
Yeah, and chiming in on getting ahead of it, legal and our email advice division and written advice here, we're taking a lot of, in addition to normal 1090 questions and conflicts, there's a lot of pre-election questions on pre-election reporting questions, new questions on the Gordon bill, change those standards a little bit, disclaimer questions. We've got, is this Facebook ad? What portion of the disclaimers does this fit in? Multi-purpose organization questions, dialing in the disclosure. They basically just call and ask, what do we need to do in this situation? For 501 filings. So Trish and Mayor and the email people are busy constantly, as well as the attorneys have an email day, where they handle a lot of pre-election questions.
I'm glad you jumped in, Hyla, because I have no right here. Legal division and E, because it is everyone, as we talked about. It's the entire staff, and enforcement gets all the glory. It's everyone working behind the scenes, and really legal trying to push compliance. The external affairs department trying to help educate people so that we don't have to go to the enforcement route. So.
Right, and the regulated communities, they're seeking to comply.
Right.
People are
Generally speaking.
Okay, let's move on before this gets.
Hopefully, I just want you to know this is what glory feels like.
I would share that. So if Hyla would like half the glory, I'm totally okay.
Commissioner Wasserman?
So the chair stated what I was going to say about how just our entire agency is essentially, the trumpets have sounded. I just voted by mail yesterday. And so, mail, robocalls, it's all out there. Activity is extremely high. It's just going to get hotter and hotter. And everyone in this agency is called upon, I guess, to do, they're probably going to go above and beyond in order to do the best for the people of the state of California. So appreciate that from everyone.
Yes, I sit up here, but it's really the staff. They do a phenomenal job. They all pitch in, and there's no real complaining. It's just, this is election season. This is the time, and everybody pitches in.
And it also is the best time for the education process, because you can lecture to people, you can get them to webinars or whatnot, but until they have to do it, until you have to do something, that extra level of support when they're doing the real on-the-job portion is critical to really get it done right. So thank you all.
Okay, anything else? Thank you, Ms. West. Okay, item 31. you want to go ahead and state your name, and then I just want to go through kind of the process here.
Yes, Madam Chair. Philip Ong, Director of Legislation and External Affairs for the Commission. Happy to be here with no thunder, though.
Okay, thank you, Phil. So staff recommendation includes one new position, and then the general concerns and other pending legislation. So I'm going to have us go through the recommended one position first, hear from the commissioners, any public comment, and then we can go through the remaining items. And I'm going to go ahead and take a jump out here on the first item, which is AB 2523. As I often feel compelled to do, I feel like I need to correct a narrative that kind of gets out there sometimes. And as I've said before, I support contribution limits. Neither the staff report nor anything that has been publicly stated supports this narrative that the commission has taken a position opposing local contribution limits. So I think that any attempt to suggest otherwise at this point is really disingenuous. And criticism regarding the approach in this bill is simply that, criticism about the approach in this bill, which I will note was drafted without input from key players, including us. So I hope that we can discuss this proposal on its merits with critical thought and legal analysis, and that any attempts to pitch this simply as an issue of the commission opposed or in favor of contribution limits could be put aside for now, because the issue really is the implementation, the administration, and the enforcement of this proposal as correctly stated in the staff report. So Phil, with that lead in, take it over.
Thank you, Madam Chair. Before you today, Commissioners, is AB 2523, which we had extensive discussion about at last month's meeting. As the month proceeded, as we were preparing for this hearing, and we saw the legislative calendar shrinking, and we decided that recommending this position was needed to ensure that the legislature and the proponents understood our position and the urgency to get these changes in print so that we could have good public policy on the books and placed properly within the law. I don't want to repeat everything that Chair Remke stated, but we believe this is a position that allows us to negotiate with the legislator and the proponents on these ongoing issues. It is not one that we can't change. Obviously, we can change it in the future. There are a few months left in the legislative process, and so we hope that you will approve the staff recommendation on this bill, and happy to answer any questions you have about how we came to this or any other concerns.
Right, and again, I'm just gonna, obviously I'm sure my fellow commissioners have a lot to say or questions, but my key concern with this approach continues to be that it is outside the act. To the extent it is outside the act as a political tactic designed to avoid the higher 2/3 vote or the potential cost attached to putting in the act, I think that really is a runaround the voters' will when they adopted the Political Reform Act and required that these issues be taken back to the voters or a 2/3 vote. Now, I understand that may make it difficult, but that doesn't make it right to avoid it. Because when we have good ideas we want to support, we're okay running around it, but what happens when we have a bad idea that we really have concerns about and someone else tries to run around the requirement? I mean, I think it is going to be very difficult to understand why this contribution limits should be placed outside the act. I understand there's an argument that there's some language allowing this to be set forth in the election code, but that same language is in the act as well, giving the discretions to locals. But everything else related to contribution limits is in the act. So that is my #1 concern. And it really is at a much higher level of protecting the act, which is what this commission is charged with doing, and the voters will. So I think to go step down this road, as lawyers like to say, is a slippery slope that I don't think we should do, because I don't see the reason to do it here. The reasons to put it in the act are far greater than the reasons to argue that it should go outside the act. Commissioners? Commissioner Wynn?
So, thank you very much. I have some concerns and comments, many of which have been made already, but I would like to hear from, supporters of the bill and the letters that we've received, and maybe I could address some of my questions to them.
Okay, we will obviously we'll be hearing from them. Do any of the commissioners have any other comments they'd like to do before we go to public comment?
I do. I have a question. And it's going to be followed by multiple questions because you're bringing me up to speed. But to avoid any misstatements, I wholeheartedly agree with the chair, with Madam Chair. I and the commission support campaign contribution limits. So that said, here's my question. My concern as I'm reading from the agenda is a recommendation that perhaps I'm not understanding. So I'm seeking some clarification from you. Among the recommendations is to give enforcement responsibilities to the commission if a local jurisdiction doesn't have or adopt its own enforcement system. Are you saying that if they do have their own enforcement system, that then we would have two parallel systems going, one system through the commission, I guess, and then one for those local jurisdictions that have their own system and want to do whatever they want to do, and whatever that means in terms of enforcement, which brings up all sorts of other questions.
That's right.
But
yeah, Commissioner Darrow, the enforcement section or the enforcement concerns are probably the most complex concerns with the bill, because we are trying to design a system somewhat hypothetically. But we also believe that the commission is best suited to deal with these as a default authority versus the district attorneys, because of our expertise in this field and the number of decades that we've been working on this and the tools that you've just complimented to Ms. West. That statement also is directed at the fact that some cities and jurisdictions already have their own ethics commissions. Oakland, Los Angeles, San Francisco, San Diego, who are up and running and have adopted some of the tactics and tools and strategies that we, as this commission, use as well. And so we wanted to make sure that we respected their jurisdictions, but not all cities have those types of resources. Those are very large cities, those are charter cities, but other cities may wish to rely on the FPPC to do the enforcement, and we believe we are prepared to do that.
Oh, and I wholeheartedly agree with that last part. But my question is, why even go down the road of separate enforcement systems? So I guess let me kind of take a step back and educate me, if you will, please. So under what authority do these local jurisdictions have to even impose their own campaign contribution limits? And so that's part A. And then part B is, does that authority also allow them to create their own enforcement mechanism? And then there'll be more.
I may have to look to Ms. Wagner for some of those answers, but yes.
Well, the Act permits them to, as it's structured, it permits local jurisdictions to adopt local contribution limits. And a lot of them have.
Very good. Right. But inconsistent, but doesn't it say, well, so what I've been reading is, even though they can adopt greater or lesser contribution limits, right?
In the bill, that's the proposed language in the
Right,
bill.
right. Okay, so that's another issue altogether. But okay, so and does the Act also provide for these local jurisdictions to create their own enforcement mechanism?
That's not in the Act about the rules on local ethics commissions, but the Act specifies that they can have their own contribution limits and they can have their own rules as to filings and things, additional within their jurisdiction as long as it doesn't conflict with the rules of the act.
So I see the commission as being better equipped, if you will, than some of the possibly, I don't know, but the local ethics commissions. And I just wonder why we wouldn't just ask for enforcement always by the commission.
Oh, we
Because
could,
I know
if that's
Ms.
what
West
this
wants
commission
more
wishes.
work.
Yes, that is something that we could do. Yes.
But we haven't done it because I think the idea is if a local jurisdiction is committed and embraces their own contribution limits and is prepared to put forth their own resources, it's best handled at the most central local location. And again, I would just also throw out, because this kind of goes to, this is not about a power grab for the FPPC seeking to grab all local enforcement. The notion, again, as you mentioned, is that we are best equipped to handle it. But we also recognize that some local jurisdictions feel strongly about handling it themselves. And if they are set up to do so, we have no problem with that. And in fact, though, often in those situations, enforcement is working with local jurisdictions. And we've seen recently where we have joint investigations and joint resolutions. So it's not a kind of an either or. We also often have to work together.
And Commissioner Darrow, the cities and jurisdictions that have adopted their own contribution limits as well as their own enforcement tools, as the chair has mentioned, have done so voluntarily. And they are prepared to spend the resources necessary to do that type of strict enforcement and understand the responsibility. This bill would essentially adopt contribution limits for thousands of jurisdictions that had not volunteered and perhaps may not be willing to put in the resources to prosecute these laws. And as we see from the letters of CSEC and RCRC, that there are concerns from the county level, at least, about these resources.
Sure. No, and I understand that. My only concern is, are we going down the road of potentially creating situations of conflicts in the way that the commission would have handled something versus how the local entity would handle it? And isn't that one of the concerns expressed earlier on?
Right. I think we run into those situations currently when we pursue cases regarding money laundering or independent expenditure coordination, and the local jurisdiction is left with prosecuting the contribution limit portion. And my understanding is they haven't been as urgent about it.
And it's been very cooperative and it's all worked, and we don't anticipate any problems with this dual system.
Well, again, I don't think we are not proposing a dual system. The bill would create multiple systems, arguably, if every jurisdiction is mandated to adopt a contribution limit and the enforcement doesn't fall under the FPPC. I think your concerns would be multiplied by the roughly 3,000 jurisdictions we're discussing when we consider special districts of 2,700. But I don't think that suggestion, and correct me if I'm wrong, Phil, about the alternative it's recognizing that certain jurisdictions already have a local. And I don't think this issue before us right now is whether or not we should have that fight of taking that away from them. The issue is more about, should it stay with the FPPC unless someone opts out because they have a system that is approved by the FPPC or at least works with us? Emma, did you have something to add?
Well, no, just adding that normally the local ordinances now, I mean, they are local city or county ordinance, so then we don't interpret them, the local agency interprets them, whether it be an ethics commission or the city attorney's office. You know, we interrelate, the PRA interrelates with those ordinances, but they would interpret, the local would interpret and enforce those ordinances.
Do you have anything? Matt? I have a couple of questions, and first thing though, I think I need to state after the number of disclaimers about the substance of contribution limits, etc., is that my questions, my concerns, my thoughts on different aspects of this issue are mine alone. So if I start talking about contribution limits and how local jurisdictions determining themselves, I want to make that very clear. That's me talking. That's not the commission's position. The commission's position isn't any single commissioner's statement or concerns or whatnot. Because I've looked at this back and forth, top to bottom. I appreciate the additional information I've received from Common Cause, which is that it's now in the packet, etc.
Are you referring to the report that they emailed you?
Report.
That was not provided as a public comment. That was just emailed to a couple of the commissioners directly.
Well, I didn't read it because I didn't see it in the actual. I'm talking about the information. Sure.
I just didn't want there to be confusion for the record.
For
The only thing that was submitted for the record was a letter.
Right, and those are substantially the information that I have received in the conversations that I had after the last meeting and then a subsequent conversation with Common Cause. They were substantially just really the same sort of topics. The other item which I received by email, I forwarded on for review before I would look at it. And since I didn't get to a point where I could look at it, it's not part of what I'm talking about. It's not part of anything I've considered. Sorry, it's nice of you to send it, but it just didn't go through the system. Okay, let me get to what my questions are. One, we talked about our position. The various folks responding on this have pushed. We've got oppose unless amended, support if amended, neutral with recommend amendments. Oppose unless amended is really our strongest position for what we tend to be articulating and basically what the commission, the direction, the overall commission was going as of the last meeting. So, and that's why we're there, because we're not nearly as strong saying support if amended. I mean, it matters to the proponents, so it must have a significant difference.
Can I jump in for a second? Because I think it's beyond the proponents at this point. Phil, Aaron, and I did meet with Assemblymember Mullen about our concerns, and I would say that it's fair to say that there was no indication of any movement regarding putting this into the act at that point. So our concerns, I think, remain at that level.
And the position that's being recommended to the commission also recognizes that as a state agency and one that's independent, we have very few tools in our legislative toolbox to leverage changes in legislation. And the positions is one of our main ones to communicate to the legislature. And so this will allow us to do that.
Okay, I'll move my second question. There's language about school districts, about community colleges, about special districts. What local governments is this proposed bill actually going to be covering? It's going to be also charter cities. I think that doesn't seem like. No, go ahead.
Our understanding, it's comprehensive. It's
comprehensive.
Yeah, it's cities, special districts, counties.
And if a city has contemplated doing contribution limits, but decided not to go forward since they haven't passed an ordinance regarding contribution limits, their inaction or action, depending on your point of view, is treated exactly the same. They would get this default contribution limit.
They would get the default.
I asked that because I've been a few travels about to watch cities, as they're trying to figure this out or later on implement it and deal with the whole enforcement issue that we brought up a couple of different times. Okay. Which goes to the question of sort of why these contribution limits don't exist in various places, but we can get to that later. In fact, I will set aside right now my questions about imposing contribution limits on local jurisdictions for one after the speakers, and I'll just go back to here's where I an absolute agreement with the chair about and the recommendation about how this really should be part of the DRA, and the slippery slope statement is entire. And I'll go to another adage, right? I'll say the road to hell is paved with good intentions. I'm very uncomfortable. I understand the real politics of it, but I'm very uncomfortable that something that refers to the definitions that everything is really about the political Reform Act would be elsewhere. And if it really is something of such broad importance, concern, support, 38 states it passed. Get your 2/3 vote. I think I'm gonna leave my other questions for after this.
Okay, commissioners, anything else, or can we ask for public comment at this point? Okay, is there any public comment on this? Like, we have Common Cause letter, League of Women Voters, and then I think the 2 opposition letters were posted as well.
That's correct, and they were posted because they were referenced in the staff report, and we wanted to make sure that the public and the commissioners knew the context and the full print of those letters.
Okay. Go ahead.
Sorry, I didn't want to loom over staff there. Nicholas Heidorn with California Common Cause. We are obviously in support of AB 2523. I'm happy to go into any of the concerns mentioned in the staff report. We did respond to them in the letter, so what I'd mainly like to do is talk about the need for this, also address some of the comments that may not appear. I think the first thing that to us is important is, yes, there is a difference between opposed unless amended and support if amended and neutral recommendations. What it means is if the author does not take the amendments and it goes to the governor, the recommendation is to oppose it, to urge the governor to veto the bill. So what that means is, because it is not in the PRA, because it does not have the commission enforcing it, you would rather not have the bill passed, you would rather not have contribution limits because it doesn't include the other components that you want. I believe that is a fair characterization.
I do not believe that's a fair characterization. Number one, you threw 2 concepts into that statement. Yes, if we oppose it, we oppose it. If it's not, one of the reasons is not to go in the act, but then you threw in because FPPC wouldn't be able to enforce it. Not the only concern, number one. And number 2, it does not mean that there will be no contribution limits, as you've implied in your letter as well. As you point out, in 25% roughly of both cities and counties, we do have local contribution limits, and nothing in this bill would prohibit additional jurisdictions that feel they need to adopt local contribution limits from adopting them.
I feel like maybe we're splitting semantic hairs. What it means
Well, I
is,
think we have to be very careful, and again, that's my concern about a narrative that gets out about the commission's position. And so I'm going to continue to split hairs until we get it right.
an opposed position states that the bill as drafted is unacceptable and is to you worse than the status quo. Correct, Chair? Wouldn't you agree with that statement? As drafted, the bill is worse than the
Perhaps,
status
sir,
quo.
you should just present your position, and our position is the recommendation is opposed unless amended. So you go ahead and present your position, please.
All right, presenting my position, I would simply point out that traditionally that is what is meant by an opposed unless amended position. Common Cause, for instance, there's a bill in the legislature regarding redistricting. We don't think it's perfect, but we don't think it would be bad if it passed. So we have a support if amended position. We go and we testify and we say, we really think the author should take these positions. That is a traditional way of voicing concerns. So fundamentally, that's probably our biggest push with regards to this bill. In terms of the need for where we think this bill is coming from, Common Cause did publish a report last month. I do have copies here if any commissioners would like to see it. Surveying what is the state of contribution limits at the local levels, we found only about a quarter have enacted contribution limits. That means in 3/4 of the jurisdictions, there are no limits whatsoever. That literally means you can donate any amount. If you want to ask your average Californian how much they make in a year, they tell you about $40,000. I'm fairly certain if you told any of them, did you know, in most jurisdictions, you could give your entire salary to a candidate for city council, they would be shocked. And in fact, that's what we're finding can happen. We found examples of $20,000, $40,000, $90,000 plus dollar contributions at the local level. Importantly, what this bill does is it only shifts the default presumption. What this bill, currently the default is, if your local government has done nothing, there are no limits. This merely shifts the default and says if your local government does nothing, it's going to be a $4,200 limit, the same as the state limit. Your local government maintains the power to change those limits, be it higher than $4,200, lower than $4,200. So we maintain local autonomy. However, we are shifting the default because we don't think that our default should be anything goes. In regards to the issues that the chair brought up regarding the Political Reform Act, this is not in the Political Reform Act. This is because it is amending the section of the Elections Code, which is precisely where it is provided that these contribution limits at the local level can be enacted. The Political Reform Act says clearly that the legislature can pass things by majority vote so long as they're not inconsistent with the PRA. The PRA is a floor. This does not contradict the PRA. We do not think it is a slippery slope. We think there are already many provisions that have been passed since the PRA that deal with other issues relating to elections outside of it, namely this part of the elections code. So we're merely amending where that is currently located. And for that basis, we think that's also a significant and important consideration. When it comes to whether or not the FPPC should do enforcement, we don't think it's unreasonable for the FPPC to do enforcement, but we also think it's entirely reasonable to keep DAs doing the enforcement. There are about 150 jurisdictions that have adopted local contribution limits. By far, the vast majority simply leave enforcement to local DAs. This bill merely extends existing practice with how that is done. We're maintaining consistency. If we created a regime whereby the FPPC would enforce it only for those jurisdictions that have not adopted limits, that would actually create a patchwork where you'd have local DAs for people who have adopted their own limits, and you'd have the FPPC everywhere else. It would also potentially create some incentives that we don't want to do with this bill. What this bill is intending to do is also incentivize locals to pass their own limits. If all of a sudden, if you didn't pass the limit, you'd have $4,200 and the FPPC enforcing. Of course, we know some people are paying $50,000 for the FPPC to enforce their local contribution limits. It might actually disincentivize people from going and enacting their local limits, which is what we'd like to do. So on that basis, we understand where the concerns from some of the commissioners are coming from. We do think there are other ways that those concerns can continue to be expressed within the legislative process without an opposed and less amended position. Thank you. And I'm happy to answer questions if you like.
Commissioners?
Maybe we could hear from Trudy too, and then,
Trudy?
Thank you, Madam Chair and other commissioners. I'm Trudy Schaefer, representing the League of Women Voters of California. We recognize that the regulation of money in politics is a very complex subject, that there are many different aspects of regulation that need to be part of a comprehensive whole, but we do and have for a number of decades believed that realistic limits on contributions to candidates is a part of that kind of comprehensive regulatory system. And for that reason, we are supporting this bill. We do think that this is a way to strengthen democracy and to curb potential corruption and undue influence. I was puzzled to hear a reference to a narrative, and it wasn't until I heard the discussion that I understood what you had understood the narrative to be, because we certainly have not been part of such a narrative, and I did not understand. I thought you meant something other than what was in writing that I had seen. All I would say is that we do support the idea that every local government in California should have an incentive and actually should have contribution limits, and so we support this idea. We've agreed that this default is actually rather high, and but that it gives the flexibility to local governments to go higher, or to, as many of those who actually have contribution limits have done, to go considerably lower. As our letter states, we don't agree with some of the points in the legislative update, and essentially we also would point out that there is the repeal of the statements, the simple permissive statements in the elections code, and actually also in the education code, as the latest amendments show. And so we feel that it was reasonable to write the bill in the way it was, and I understand that that's a subject for discussion. And also, as Mr. Hydorn pointed out, those jurisdictions that do not have ethics commissions but do have contribution limits have been operating with the enforcement in many cases, or most cases, I believe, by their DAs. And so for that reason, we hesitate to believe that it would be that confusing to make that be the default.
Can I just ask a question? Do you have any statistics or information on how many district attorneys have brought cases regarding over the limit contributions?
I do not. I don't know if the commission does.
are you finished? I have a couple of questions, but I'd let you finish.
I was just going to state that we agree with the idea that we believe all states and the local governments within those states should consider and should have contribution limits as part of their overall regulatory scheme. That obviously disclosure, and we hope at some point limitations on expenditures and some kind of public financing of campaigns is part of the system that should exist. But at the very beginning, we believe that it's a step in the right direction to have the contribution limits.
Thank you.
Is that all right?
Commissioner Wynn?
Thank you very much, and thank you very much, both of you, for your comments. So I support contribution limits, and I actually support a default. So I think that's not a bad idea. So just, I don't know that the commission has ever taken a position on that. So that is just my position. You know, many years ago, I worked in an area of law called, you know, child support enforcement, and DAs were responsible for doing child support enforcement. So in addition to rape and murder and burglary and everything else they were supposed to do, they were also supposed to enforce child support orders, and they just didn't. And it, you know, the system was completely out of whack, and they didn't like doing it because it's really hard to do, and you really have to have a certain expertise. And there were a whole bunch of other things that were kind of more interesting, made the paper. So, you know, about 20 years ago, the state took that away from DAs. And I don't know that it's dramatically better, but I mean, at least you now have experts doing enforcement of support orders. So instead of, you know, trying to get your DA's attention who's out in court every day doing other things, we now have an expert enforcing those orders. So that's kind of my sensibility, where if you get a DA who has a very busy office, this is just not going to be the kind of thing that, you know, they're good at or that they know how to do, and they're probably going to have to go after their county supervisor who's responsible for their budget, or a city manager or whatever. Anyway, I don't think it's a great enforcement model. And I also do believe that this kind of, you know, limit should be in the PRA. So that's my sensibility. And I just thought I'd put that out for the record.
Okay, thank you. Commissioners? Commissioner Wasserman, anything for you?
I'm gonna wait a little longer because
Well, I think I think our comments are done.
Is that it?
Is there
No
any
more
other public comment?
okay, well, I guess I won't wait a little bit longer. Yeah, I want to emphasize something that was previously stated about we're not really looking for more work when we talk about capability, expertise, etc. Because everyone knows that if we get this much work, we will get this much funding. So it's not like, you know, it's some sort of windfall for the entity itself. You know, my experience is similar to Commissioner Wynn's with respect to expertise, resource allocation, etc. among local prosecutors, and these kinds of misdemeanors for which most prosecutors going through their rotation of, you know, what they're, the phrase baby DA, for those of you who are known to the WDA's office, as they rotate through these things, these are not the things that make your career, and it's probably not what you got involved to do in the first place. Still, if it's your job, you should do it. You should do it well. You know, I have this, and this was brought up last time, and I appreciate the back and forth we had on it. I have this real concern about the local control, because I've watched some of these local governments, some who are in process and some who have established contribution limits, and they really need to think about the other things that happen here with contribution limits. Assuming that people actually are complying with the reporting requirements, contribution, when they contribute, and if they're reporting requirements, then you know who has contributed. Okay, that's sort of a perfect world version. I understand we wouldn't be here if that always worked. And then you have your contribution limits, and we talked about a high default and etc. But so you have your contribution limits. So then you have your independent expenditures. You have your issues, and that's folks who are actually complying, right? They're doing an truly independent expenditure. But that is one more step for the public to try to figure out who's the funding influence, the influence that someone is concerned about paying, a corrupting influence, to get that information. And then you get into the bad actors. well, they might not report anyway if there were no contribution limits or if there were. But then you also have our issues of coordination and laundering, etc. So I'm going to emphasize that my concerns about those areas, again, are my concerns, not commission positions. But we've lived enough under scenarios in different jurisdictions, local government, statewide, etc., with contribution limits to see what the consequences are otherwise. So and the basic premise about they're always going to be a good idea is one that I think we always need to think about in the context of when we're addressing adding new ones. You know, ones that we enforce, they are the law. But, and then the methodology and who has the control. But again, with respect to the aspect about the PRA, I'm not convinced that, because I think the emphasis I have here on that aspect about there being a small portion, I forget how long it is in the election, I don't want to understate it, but in the election code, and whether or not the statement was we can do this. Well, really, should we? Should we be taking that step to do things that really, if you weren't in an advocate's position, advocating for a result, you say, well, this really ought to be over here, because the government at any level constitutionally can end up doing a whole lot of different things that we may not like. But that's the purpose of having decision makers to say, well, we can do this, but should we? And even if the argument is correct that it could be done in the elections code, I don't think it should be. And, you know, to hang it on a particular section would be, I mean, this also amends the ed code as well, right? I mean, but that's not sufficient nexus to take
repeals one provision of the ed code that addresses
contribution limits to those entities. So, you know, when we talk about consensus, we may not be agreement as to some of the other things that I'm concerned about, but I think that I'm in agreement with that overall idea that we sacrifice really too much by going to a result that even if people, even if a majority of the commission might want that result, they will not take that road to get there.
Any other comments from the commissioners?
I'm not a commissioner, but I wanted to make sure that you knew that I had my flag.
Okay.
Yeah, thank you, Madam Chair. I did want to respond quickly about the position of oppose unless amended. Mr. Hydorn mentioned that not every vehicle that they have supported or not opposed was perfect. I would just mention that as a state agency that's empowered by the voters and by law to administer and interpret and enforce the law, that our position is different than that of a private stakeholder. And so we do need to do our best and ensure that these legislative vehicles are as close to ideal as possible, so that the enforcement is ideal for the voters who I believe have entrusted us with an enormous amount of power and trust. And I would also add that when positions go to the governor's office doesn't always presume or assume our positions over policy. We do communicate with them when they request communication about why it is that we oppose certain legislation. Thank you.
Thank you. If there are no other commissioner comments, is there a motion on the staff recommendation?
I move that we approve the staff recommendation as well.
I'll second.
Commissioner Adara,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, so now moving to items 2 through 4:20, really, because I'm opening the door. And I'm really gonna just do this first real quickly, Phil. Is there anything that has significantly changed that's worth noting at this point, other than just a bill continuing to move that you need to update the commissioners regarding?
Nothing has changed. I would just flag that there's an important legislative date that is coming up next week, which is the deadline for the respective appropriations committees to make decisions on what they call the suspense file. All of the bills that are indicated to be an appropriations committee that are Political Reform Act bills are on the suspense file. Generally, when the legislature decides to hold a bill, those bills are dead for the year. If they let them out, they usually let them out of suspense file with significant amendments. And so when we see these bills again in July, you will see them because they're on the website now. But after the end of May, many of them will be significantly changed. And many of them will have amendments to them that have been negotiated with staff as we've been in consistent contact with these offices throughout the process.
Executive Director Beth.
Yes, I just respectfully disagree with my colleague because there is an important development that we need to update the commission about, which is that the governor vetoed Assembly Bill 1200, which the commission had a formal opposed position on. He vetoed, we got word that he vetoed that bill last Friday. So that was obviously after the staff memo came out 10 days before the meeting. So anyway, the result of all of that 2-year bill is that the governor has vetoed that bill.
I don't think we're in disagreement with that one, but
Okay, well, that's good. We got it. Any questions from the commissioners regarding the remaining bills on the list?
Well, actually, I'm going to ask about 12.
Sure, go ahead.
1200. So, I don't suppose, since it was so recent, that there's any further information from Assemblymember Gordon about attempting to do anything in the future regarding procurement, maybe not within the PRA. I mean, is this something that's going to come back to us at some point, or is it pretty definitive?
We have not heard any indications otherwise, but we believe that, or at least I believe, I want to make sure I speak for that, the governor's veto message was pretty strong that the procurement process is the way he likes it.
Because the procurement process is, I mean, I had no disagreement with the assembly member about how important the procurement process is, since, I mean, it's, again, one of the areas where the rubber hits the road, where money from the public trust transfers into private hands. It's just, I think this time, I think I can say, yeah, the commission position was what it was.
Any questions or from the commissioners regarding the remaining items? Okay. Thank you, Phil.
Thank you.
And then we have the staff reports. Any questions or comments from the commissioner on the staff reports? Commissioner Wynn?
Ms. Wagner, just a question about the Burgess matter. So I know the briefs were filed May 2nd, but do you have any idea of a timeline? So you just said the court will schedule a hearing. I mean, would that be this summer? Would that be this fall? Or?
Good question. We do have the briefing timeline. Our reply is due June 7th, and then they have one for the brief, but there's the date for the hearing isn't scheduled yet.
But we should definitely know by July what the status is, hopefully, unless, of course, we might not. Anything else? Commissioner Wasserman?
I just had a couple of things, but I guess the gist of it is I really appreciate these reports and the detail. I know we congratulated John Kim on his moving into being a consultant before, but I thought, Sai is named. It's always nice to see people working and achieving and doing more things in the agency, since John was our commission. Mr. Kim was our commission assistant previously.
Don't give Sheila any ideas.
No. I'm done with it. I have one joke. It did well. I'm done with the jokes. So, that was really it. And I think the other questions were covered mostly in the process of looking at each of the cases. So all these other ones,
Yes, Wes.
I just wanted to give one follow-up report that, if you remember a while back, we did a joint venture with the OCTA, prosecuting Mr. Sunwind for laundering. And I would just like to let you know that we received our cashier's check for our portion. And so we have gotten the reimbursement from the committee and the disgorgement, and now we've gotten the payment. So that is all paid in full.
Great, thank you. Okay, if there aren't any more questions or comments, I move to adjourn.
Second.
Commissioner Adara,
Yes.
Commissioner Wasserman,
yes.
Commissioner Wynn,
Yes.
Chair Remke. Yes. Motion passes.